Welcome to this morning's webinar, the Belgian insurance webinar, which in a slight change from the advertised agenda, will be chaired by Hugo Keulers, Managing Partner of Lydian, and Alexander Hamels of Lydian. So thanks to both of them. We look forward to hearing their thoughts in a second. My name is James Wood, Head of International Content at the Legal 500, and I'm sitting in London today, as are several of the legal counsel in our audience. It's the 2nd of July, I think. I should actually check the date, but I think it's the 2nd of July, which means that the UK has now passed the deadline for negotiations in Brexit. So essentially there is going to be no extension. Therefore, on the 31st of December, there's a very real possibility of a no deal. What that might mean for UK insurers is, of course, an open question, but I'm sure everyone's already identified a potential European home and new European home, and among those countries will be Belgium. So obviously all sorts of questions arise, what a Belgian base will mean for UK insurers looking to sell to the EU market and the freedom of services. And compounding that, of course, is COVID-19. So today we'll not just be looking at the question of Brexit, but also what COVID-19 and a host of other issues mean for the European insurance sector from the perspective of Belgian law. So hopefully this will be of relevance to insurers in France, Spain, elsewhere throughout the EU. So with that, I will pass over to Hugo for his introduction. I will just say finally, we do hope to make this interactive. So if anyone has any questions throughout the presentation, please do use the question box on Zoom to submit them. We'll deal with those questions at the end. We want to hear from as many of you as possible. Hugo, please.
Thank you very much, and also on behalf of everyone at Lydian, a warm welcome to this webinar. Let me start, however, with an apology on behalf of my partner Sandra Lodewijks, who cannot be with us today because of an urgent assignment. These are obviously very peculiar times. This would be around the time of the year that we would be traveling to London to meet all our clients, contacts, and good friends in the industry to share experiences. We're very glad and happy that we can now do this by way of a webinar organized by Legal 500. We're going to deal with two big parts in our presentation. The first part will be done by my colleague Alexander Hamels and deal with the more regulatory side of the insurance industry and talk about some of our experiences with Brexit strategies, both for insurers and brokers. Then I will take the floor and talk to you about the insurance claims landscape in Belgium, in particular in relation to COVID-19 disputes. We wish you a very pleasant and educating webinar, and if there are also any questions after the presentation or the webinar, please don't hesitate to reach out. I pass on the floor to Alexander now.
Thank you, Hugo, and also on my behalf, welcome everyone at this webinar. I've seen in the attendance list that we have a very diverse audience. So we have very specialized attendees, legal counsels in Belgium. We also have participants from the UK, maybe in a group structure, and we have lawyers. So we have tried to make it interesting for everyone. Maybe the beginning of the presentation may sound a bit basic for some of you, but this is done in order to get everyone up to speed for the more technical parts where we will share our experiences with you. So this button does not work. One moment. I have a technical problem here. Okay. So, first of all, we're going to discuss Brexit and the regulatory developments surrounding Brexit. And afterwards, Hugo will discuss more the litigation side of COVID-19 and the legal framework surrounding it. So first of all, as I mentioned, I'm going to start the presentation with explaining some basic principles of Belgian insurance regulation relevant for Brexit. And then secondly, I'm going to share with you our experiences with the impact Brexit had and still has, and the current challenges insurers are dealing with, and also, of course, insurance intermediaries are dealing with. First of all, as a general introduction, how is insurance regulated in Belgium? So our two main bodies of legislation are, on the one side, implementation of the Solvency II directive in the law of 30 March 2016, and then secondly, the IDD, Insurance Distribution Directive, has been implemented in the insurance law of 4 April 2014. Belgium is still a kingdom, so that means that laws are implemented via royal decrees. Of course, the king only has a formal, symbolic function. A royal decree is a governmental decree, but important in the context of insurance, we have a lot of royal decrees that also apply on insurance business. How is supervision organized? So we have a Twin Peaks model of insurance regulation and supervision. That means in practice that prudential regulation is attributed to the National Bank of Belgium, whereas rules of conduct and regulation and supervision on insurance intermediaries is delegated to the Financial Services and Markets Authority, or abbreviated the FISMA. So some general observations on Belgian insurance regulation. First of all, which is quite important for foreign regulated entities moving to Belgium or having business in Belgium, is that our regulators speak English. That's not the standard language. We have 3 languages in Belgium: English, French, and German. But if you as a regulated entity speak English, the regulator generally adapts to that language. For example, most of the circulars and regulations are also translated into English. You could mail the regulator in English or have meetings in English. Secondly, if you have doubts on the compliance of your activities or your organizational framework, there are 2 ways to get guidance from the regulator well in advance for your particular situation. So you have your preliminary rulings, which is a formal procedure and which is also binding upon the regulator and the regulated entity. But most importantly, you have the possibility to have informal conversations. So that means that without being bound to a certain instruction of, for example, National Bank, you can check whether a planned project would be compliant or not. And you can even do it on a no-name basis, what we as lawyers actually do quite often to check our conclusions with the National Bank, of course, always if instructed by the clients. Secondly, the Belgian regulators and supervisors are experienced, well equipped, so we can definitely say that there is solid regulation and supervision comparable with our neighboring countries, to be fairly honest. And then a fourth general observation, the approach towards regulated entities is not focused on sanctions, but rather on prevention and remediation. So that means if there would arise a problem, the regulator will first try to solve it together with the regulated entities and to prevent further breaches. Of course, if the breach continues, there may be sanctions. And we also see at the side of the FISMA, so the rules of conduct, a priority towards the requirements to work together with regulated entities. So if you work together with an intermediary who has no registration, that become problematic, and there we see some fines. But in general, and especially for insurance undertakings, the focus lies with prevention and remediation. So for an insurance undertaking, what authorization requirements are there? So I assume in the context of Brexit, if you are reorganizing your insurance group, you already have done this. We are now 2020. But as a general introduction, I can say there are very comprehensive rules on the organization and functioning of the insurance undertaking, as in all EU states. But most importantly, in Belgium, the principle of proportionality is very well developed. This is not the case in all member states. So we see in all three pillars of Solvency II, the principle of proportionality reflected. So that means if you are a small insurance undertaking or an insurance undertaking with less complex activities, you get some derogations from the very complex and comprehensive requirements of Solvency II. So as an example, for the calculation of certain risk modules, you can apply a simplified calculation. With regard to governance requirements, there are a lot of derogations and exemptions on the standard governance requirements set out in a circular of the National Bank. And then finally, in the third pillar, also for your reporting requirements, there are exemptions and derogations. I'm thinking about the content of the own risk and solvency assessment, ORSA, or the frequency of the regular supervisory report, the RSR. For insurance intermediaries, on the other hand, there is no principle of proportionality. So this means that even if you want to set up an insurance intermediary more pro forma to ensure market access in the EU post-Brexit, you will need to apply all rules on the organization and functioning of the insurance intermediary. And as I said, if you want to establish a more pro forma insurance intermediary, we always warn for the prohibition of empty shells, which means that you actually have to use that insurance intermediary and not just establish a mailbox company. But I will revert back to that later when discussing Brexit challenges. One of the main positive experience we had with regard to Brexit-related applications is that the FISMA for insurance intermediaries is quite open and flexible. So they are willing to informally review your application prior to submission, which has a lot of benefits, especially with regard to formalities and administrative burden. There's very often that somewhere a word is missing or that a certificate does not use the correct wording and so on. So it's very helpful from the FISMA to allow us to informally discuss those kind of applications. A last remark, something specific to Belgium, are the division of the Register of Insurance Intermediaries and Reinsurance Intermediaries into different categories that does not exist in some other member states. So we have 6 categories. We have our agents, sub-agents, we have brokers, the IDD category, ancillary insurance intermediaries, and then finally, a category which was introduced because of Brexit, the mandated underwriters. But for that last category, I will come back to that in the second part of this discussion. An observation with regards to the establishment of insurance undertakings intermediaries. Of course, undertakings are more stringently regulated than intermediaries. So as an intermediary, you can basically use all corporate forms, and even a self-employed person can register as an insurance intermediary. However, I have to bring a bit of a nuance in this notion of all corporate forms, all Belgian corporate forms. So it's a requirement to set up a Belgian company. With regards to directors and senior management, so for both insurance undertakings and intermediaries, fit and proper requirements apply. Although these fit and proper requirements are comprehensive, we do note that you do not have to be a Belgian national, or you don't even need to speak the language. So if your native language is English, that's no problem to pass your fit and proper test. However, you may meet some challenges with regards to training requirements, and there the languages in which they are organized. But again, I will discuss this part in the Brexit specific discussion. There is a distinction between FISMA notification and MBB approval. So directors and other regulated positions in insurance undertakings need to be pre-approved by the NBB, while for insurance intermediaries, a notification to the FISMA suffices. However, a notification in reality, it has the same effect as an approval, to be fairly honest. And then there are specific requirements for persons in contact with the public and persons responsible for distribution. I'm mentioning this specific requirement because it's also specific to Belgium. I know this defined term of person in contact with the public, that's unique for Belgium. Also persons responsible for distribution. Who is that person? It's more or less a senior manager. We have seen for insurance intermediaries that it's most of the time the only director, or for larger insurance intermediaries, and so a company that has more than 10 persons in contact with the public, you have several persons responsible for distribution, which are the senior managers, let's say. And then for insurance undertakings, we have, of course, our independent control function, internal audits, risk management, compliance, and the actuarial function. These are, of course, in all member states, regulated positions. So let's dig a bit deeper into the requirements for Belgian insurers and intermediaries, especially in a context where activities may be low at a certain point of time. And let's have a look at the substance requirements. So what is the minimum substance you need to have when you have an insurance undertaking in Belgium? The general rule is, let's say, that there is a prohibition on empty shells. So a mailbox company is prohibited, which means for insurance undertakings that your central administration needs to be in Belgium. Central administration, it's a broad term. What does it mean? You have your overarching governance circular in Belgium, published by the NBB. And there the NBB clarifies that your central administration means that your nerve center of the company, where the decisions are taken, that nerve center needs to be physically located in Belgium. So in practice, you may hold your board meetings in Belgium. You can place the independent control functions on the payroll, or have your general meeting in Belgium. But again, if a problem would arise with regards to the prohibition on empty shells, we always advise to look at this on a case-by-case basis, because it's quite a complex question. Secondly, for insurance undertakings, we have the requirements of active risk management, which means that you cannot reinsure 100% of your risk to, for example, your UK parent company. According to EIOPA guidance, you need to have a retention of at least 10% of risk. Thirdly, and that's more of a general requirement, an insurance undertaking must ensure effective and prudent management. This relates to substance requirements because, for example, in case of excessive outsourcing, National Bank could argue that if you outsource all essential operations, tasks, and positions to a service provider, that you're no longer ensuring effective and prudent management. And then finally, the use of license. So you may or may not know that the granting of licensing is not harmonized, so it's still a domestic competence. And Belgium has a rule that you effectively have to use your license. So which means if you're registered in a specific clause, you need to take on risk for at least once every 6 months. For intermediaries, these substance requirements are less detailed. So we have our general requirements of a prohibition on empty shells. What does that mean in practice? It's more difficult to establish because we don't have our governance circular for insurance intermediaries. But we personally advise that, for example, having your board meetings in Belgium is advisable, and having your central administration in Belgium is advisable. So let's go to the next step and dig a bit deeper into Brexit and the challenges they have it has created and it still creates. So we have advised a number of insurance undertakings in their move to Belgium and in their current operations in Belgium. We are also advising a lot of intermediaries who are following, in some cases, Lloyd's, the cover holders or the MGAs who are following Lloyd's to Brussels and who are trying to comply with Belgian requirements. So we have learned quite a lot from that experience. So first of all, and of course you all know the first observation, after Brexit, regulated entities will lose their passporting rights. So in principle, they need to establish a new regulated entity within the European Union, or better, the European Economic Area, and then exercise passporting rights in the other member states. Probably we will not have a deal. The withdrawal agreement is currently bound to fail, but I have to admit, even if it would be signed, it would have a low impact on the main problem of Brexit for insurance, being the loss of passporting rights, for the simple reason that the withdrawal agreement does or did not include a framework for passporting rights. So there is a reference in the withdrawal agreement with regards to UK equivalence status under Solvency II, but even if that equivalent status would be granted, it may have relevance for reinsurance arrangements or group supervision, but it does not allow market access for UK regulated entities in the EEA. We have seen on the European level that there was, let's say, a non-sufficient response to the problem of Brexit for regulated entities. So let's have a look to the Belgian response to Brexit. So first of all, we have our general attitudes of the regulators, which was, as I discussed before, positively received. So first of all, we have our language, we have our flexibility, and thirdly, we have our firmness with regard to supervision, which is of course important for the credibility of the group. Secondly, we have the law of 4 April 2019 on the withdrawal of the UK from the EU, the so-called Brexit law. And in that Brexit law, we have two main initiatives to give a response to Brexit. First of all, we have the introduction of a new category of insurance intermediaries, the mandated underwriter. If we look at the preliminary works of the law, there is a reference to Brexit and is specifically introduced as a response to Brexit. But in all honesty, I have to admit that we already had a lot of activity of mandated underwriters in Belgium, and that before the entry into force of that law, they were just registered as a broker, an agent, or a sub-agent. But for a company that is used to operate under the registration as an MGA or a cover holder, it may be a useful category to register in, especially if you're used to work like that. Secondly, Article 20 of that law provides for a delegation to the King to introduce a temporary framework for run-off business, meaning closed book operations, where an insurance undertaking does not accept new risks, but still manages the existing portfolio upon maturity. That temporary framework is not yet in place. We are aware of initiatives to put such a framework in place. We have seen the text. Unfortunately, this is still confidential, so we can't share it with you in the context of this webinar. But if you're interested in learning more about this temporary framework for run-off business, please send us an email and we can definitely discuss with you how it will impact your company. And maybe set up a meeting with the relevant stakeholders to discuss your particular situation. Then thirdly, we Belgium welcomed a number of new insurers in Brussels. New insurers, well, of course, they already had activities in Belgium, but they chose Brussels as their main head office for their EEA activities. Lloyd's is, of course, the most known or the biggest name that came to Brussels, but we also have QBE, Enstar, and MS Amlin, also very big insurers who chose Brussels as their new EU hub. Other insurance undertakings chose Luxembourg, Ireland, Paris, or Germany. But of course, we're very happy to assist some of those UK insurers here in Brussels. I didn't mention all insurance intermediaries, but in the context of the move of those insurers, we had a lot of intermediaries moving also into this country. So in terms of challenges, there are a number of challenges, practical challenges or very complex challenges that we saw insurers and intermediaries dealing with. We're not going to discuss all of them. We can speak a whole day on all those challenges and complexities. But some general observations I would like to share with you. First of all, the administrative burden. Probably it's a bit everywhere in the EU if you're moving a regulated entity to another company, that you need to deal with the administrative burden, maybe change of culture. Belgium is not Italy, but still it may sometimes be difficult to get everything approved, taking into account all formalities. One example, or for example, the recognition of foreign degrees. Let's say that a senior manager has obtained a degree in a very renowned university in the US, then still he will need to get a recognition via a specific institute in Belgium, being NARIC on the Flemish side. Then secondly, we have our assessment of fit and proper requirements. There is no EU framework for the fit and proper assessment. This is sometimes frustrating in the context of bigger groups who want to appoint the same persons in different member states and need to go through the fit and proper assessment in each and every member state. I understand that there are discussions on the European level to change that aspect, but up to now, it remains a challenge. Thirdly, the language of the trainings for your qualification as a senior manager or for your continuing training may be challenging. There were, up to now, some of the trainings are only organized in Dutch and into French. For example, the FISMA exams for insurance intermediaries. So that's frustrating, but we do see the market of professional trainings adapt, and we are aware of training institutes who will introduce very shortly English language training. I think it will be in September, but I'm not sure. And then secondly, you have other solutions. Also, you can organize your in-house trainings or tailored trainings, which we as a law firm also do quite often for clients. So two more challenges. Outsourcing. We have, very importantly, so outsourcing is regulated in Solvency II, Solvency Delegated Regulation. you have your EIOPA governance circular, and then you have your Belgian guidance of the MBB in your overarching governance circular and the cloud outsourcing circular. So that's everything. I know it's a lot. But what is important now on the 2nd of July is that the governance circular has been revised in last month in May. And there are specific rules on outsourcing of important functions or activities outside the EEA. So within the context of Brexit, it's important to assess whether your current procedures and outsourcing arrangements still comply with the governance circular, which they may not, or maybe you have to make some minor changes. Secondly, insurance distribution, outsourcing of insurance distribution remains a difficult issue. Insurance distribution is regulated under the IDD, outsourcing under Solvency II. However, if you outsource insurance distribution, you must make sure that your service provider is registered as an intermediary. So outsourcing distribution to the UK may in some instances be a challenge. And then finally, with regard to outsourcing, we have our provision on empty shells, which can be problematic in the context of very developed systems of outsourcing, where, for example, you divide your insurance undertaking into two companies, one who takes on the risk and the other who ensures operational activities. Then there may be a challenge with regards to empty shells. And then a final observation is the alignment of classic UK business models with continental laws. We use the word continental and not Belgium because it's more difference of a common law with continental law rather than Belgian law with UK law. And for example, I'm thinking about this concept of trust, which is I'm not talking about trust funds, I'm talking about the general concept of trust in the UK, which is very well developed. I'm thinking, of course, about trust funds, but also about fiduciary duties, discretionary indemnity arrangements, the takeover panel for M&A transactions. And we also see in insurance that may conflict with our concepts in continental Europe. For example, discretionary indemnity arrangements. What is a discretionary indemnity arrangement? It basically means that the insurer can freely decide whether or not to cover a claim. So because the insurer has that discretion, it falls outside the scope of insurance regulation. The product is not considered as an insurance product and is allowed in UK, for example, in liability insurances, therefore for dental insurance. That's one example, but you have many more. We have looked at those arrangements in Belgium for a number of service providers for different purposes, and in each and every case we considered that they may be quite problematic in Belgium because we don't have that legal concept of trust. We have good faith, but it's something else than your concept of trust. Then secondly, and that is my final remark, a comment on outsourced service providers and business process outsourcing, so OSPs and BPOs. So I know in the UK it's very common to have two companies, your insurance undertaking and your operational service provider, which some Belgian insurance undertakings also have. However, it's less developed. So if you outsource all activities to that service provider, including distribution, including your key control functions, including even your senior management, that may create some challenges with regard to substance requirements and the prohibition on empty shells. But in any case, for all of these challenges I just mentioned, there are solutions available. So if you are struggling with them or if you are now on the basis of this presentation realize that there may be a comparable situation within your company, we are very happy to search together with you for solutions to make it work. So that was the part on Brexit. Thank you very much for your attention. I'm now going to give the words to Hugo, our managing partner, who will discuss COVID-19 challenges.
Thank you very much, Alexander, for a great presentation. I will talk to you about the Belgian insurance claims landscape, because I suspect that for some people this is still uncovered land. And then I will also deal with COVID-19 disputes and the way they will be dealt with under Belgian law insurance contracts. I've structured my presentation around a series of questions, and I thought it was worthwhile to remind you that under Belgian law, insurers are not absolutely free in the wording of their insurance policies. And that also includes insurance policies for industrial risk or financial lines. The reason is that we have mandatory insurance contract law laid down in our April 2014 Insurance Act, which is a big law. It was also mentioned already by Alexander in his presentation. And this has far-reaching provisions dealing with, for instance, the formal requirements for gross negligence exclusions, the liability for insurers to also pay for salvage costs and interest and judicial cost and liability insurance above the amount of the insured limit, all statutory provisions which can be quite troublesome for insurers who want to do business on the Belgian market. Apart from this general insurance act, there are also a number of specific insurance law, which are not necessarily always the result of the implementation of an EU directive, such as the Third Party Motor Liability Act, but which are also typically Belgian in origin. For instance, we have a law that provides for strict liability for restaurants, movie theaters, hotels in case of a fire, with linked to that an obligation to ensure that strict liability under mandatory terms and conditions. And the whole of that leads to the conclusion that insurance contracts are pretty much regulated under Belgian law, and our experience in the review of policies that originate out of London or the US is that when you want to offer them on the Belgian market, there is quite some rewriting that needs to be done. In terms of language of the insurance contract, a distinction must be made, and that's very often the case under Belgian law, between policies underwritten by consumer policy holders, individual life insurance, health insurance. Those policies must be written in French, Dutch, or German, which is the third official language in Belgium. But for the whole area of industrial risk and financial lines, such as all risk property, such as cyber, D&O, professional indemnity or product liability, there's a freedom to draft insurance policies in English, and the market practice is also such that these policies are very often in English. In terms of interpretation of insurance contract, the same distinction between consumer policy holders and other insureds comes up again. For consumer insureds, the interpretation of an unclear provision will always be in favor of the insured, according to Article 23 of our 2014 Insurance Act. For other types of insurance policies, judges or arbitrators will have to look to the common intention behind the insurance contract, which they will try to find in underwriting files, exchange of correspondence or communication between brokers and insurers. That is because Belgium is a civil law jurisdiction where evidence is very much based on contemporaneous paper trail and not on the hearing of witnesses. How are insurance claims usually resolved in the Belgian system? Is it by mediation, arbitration, or state court litigation? Well, let me first start off by saying that mediation is, in our experience, not very often used to resolve insurance disputes. Unlike the London market, we don't have a large experience with mediation as a mechanism of dispute resolution for insurance disputes. This doesn't mean that these type of disputes do not get settled. They very often get settled, but it's possible to settle them without the help of a mediator. Only again, in the consumer type of insurance disputes, there is the ombudsman, and you must even refer to the ombudsman and his competence and his jurisdiction in your policy. And sometimes, especially in life insurance, for instance, individual policyholders, when they are dissatisfied with the behavior of their insurer, may go to the ombudsman, who will give an advice and try to reconcile and mediate between the parties. Arbitration is a peculiar thing because it's not always allowed in insurance policies. It's not allowed in the insurance policies for consumers, for instance. It is allowed, luckily, in all marine and transport insurance policies. That is because these policies are not governed by the April 2014 Insurance Act, and there's a freedom of contract that applies. But also in the more sophisticated insurance contracts like industrial risk, D&O, I've named them on the slide, arbitration in the insurance policy would be allowed and will be allowed. They are effectively also used in these type of policies. And there's like a 50-50 division between ad hoc arbitration or the so-called CEPANI arbitration, CEPANI being the Belgian Arbitration Institute. You will not often see an ICC arbitration clause, for instance, in a Belgian law-governed insurance policy. Finally, there's the state court litigation in front of the state courts. What you should know about that is that litigation before the state courts will always be conducted in French or in English, in Dutch. It's not possible, therefore, to conduct state court litigation in English language. So if an insurer wishes by all means to have its disputes being conducted in English language, the only way to do that is by choosing arbitration, because in arbitration the language can be freely chosen. Our courts do not have the best reputation in terms of being fast or slow. It is possible, for instance, the Brussels Dutch-speaking Court of Appeal, it's not exceptional to have a duration of 5 years run through before you get a judgment. In terms of burden of proof in liability and coverage disputes, in liability claims, the basic principle is plaintiff will have the burden of proof. If a defendant wants to rely on a contractual or statutory defense, such as act of God, force majeure, like in the COVID-19 times, he will have the burden of proof in that respect. Now, all of that is to an extent set aside by the practice we have in Belgium for technical cases, like for instance, after a fire or an explosion, courts will rely on the advice given by a court-appointed expert. And this court-appointed expert will follow a contradictory process involving all of the parties in the litigation. It's the same system, for those who are familiar with it, than is used in France. If you come to the court with your own individual expert's report, the evidence value of that report will be fairly to very limited. Coverage disputes, on the other hand, follow another pattern. There, the insured firstly has the burden of proof to demonstrate that his claim falls under the scope of cover of the policy. But if the insurer wants to rely on an exclusion clause or a forfeiture ground, then the insurer will have the burden of proof in that respect. Case law now is sufficiently established into that direction, into that sense, to take that position. Insurers will also have a burden of proof with respect to time bar and statute of limitations. The statute of limitations under Belgian law for a coverage claim is 3 years. I believe in England it's 6 years, but it is possible to get an interruption provided for by the law in case of a timely notification of the loss or the claim by the insured. The statute of limitations will stop to run until the insurer will have notified the insured in writing and unambiguously that his claim is rejected. Then the statute of limitations will start to run again. Now, is Belgian case law generally favorable to insurer or insureds? It's a question that is often asked to us. It's not a question that you can resolve by referring to hard facts, figures, or rocket science. It's a question of feeling and experience. And our experience with the Belgian system is that, especially in first instance and appeal, it will treat insurers fairly. Also because we have this mandatory law, and judges tend to think that the mandatory law sufficiently protects the interests of insurers and policyholders already. A bit different at the level of the Supreme Court, our Cour de Cassation, because in the last few years, on a number of principal questions, very recently on the interpretation of the loss occurrence principle in liability insurance, we have seen judgments that tend to be in favor of insured parties. And the ground or the motivation that is given by the highest court is always that it's an interpretation of a statutory provision that was introduced to protect the interest of the policyholders and the insured, and therefore, if there is a dispute about their interpretation, it should be resolved in favor of the policyholder or the insured, whilst sometimes disregarding the intention of the legislator behind that particular statutory provision. So that's a development that clearly must be more closely followed, which we are obviously doing. Now, in our experience, the most troublesome statutory provisions for insurers in our Belgian Insurance Act, I've listed them on this slide, but I'm not going to discuss in detail all of them. Let me take, for instance, the first one, the procedure that must be followed by insurers in case they observe that the premium is not paid on maturity date. Belgian insurance law allows insurers to provide in the policy that the coverage will only take into effect after the full premium will have been paid. Only market practice is not such that this is often chosen or applied by insurers. So if it's not chosen, the mechanism you need to follow, if you see as an insurer that your premium is not paid at maturity date, is that you have to send a first registered letter or even a bailiff's notice, but nobody is obviously doing that, to remind the insured or the policyholder of his payment obligation, and remind him also that if he doesn't pay within a delay of at least 15 days, you would be entitled to suspend or terminate even the policy. But if you want to proceed with such suspension or termination, you will need a second registered letter before you can actually proceed that. That's a quite heavy administrative burden that insurers carry under Belgian law. In terms of gross negligence exclusions, principle under Belgian law is that gross negligence is insured. However, insurers may exclude gross negligence, but only for those cases of gross negligence which are defined in a limited and express manner in the insurance policy. And that's a very, very tough condition to meet. Most of these exclusion clauses that we see in insurance policies are set aside by Belgian courts because they do not meet the formal requirements, which practically boils down to the observation that gross negligence is basically always insured in a Belgian law insurance contract. And finally, the obligation for insurers, I already mentioned it, to pay salvage costs, but also interest and legal costs in liability insurance, even above the insured limit, says the law. However, with the possibility to provide a cap above the insured limit. This cap, however, is dependent upon the amount of the limit itself, is laid down in the law, and must be written down in the insurance policy. If it is not written in the insurance policy, and I've recently seen a constructional risk insurance policy issued by London underwriters governed by Belgian law with a Belgian insured, which didn't have the cap. So that means that you would have an unlimited obligation for interest and costs above the insured limit, which is obviously a very unpleasant experience in a litigation that sometimes may take 10 years or more before a Belgian court. One further peculiar thing of the Belgian insurance law is that the victims, in case of a liability of an insured, basically always have direct claims rights towards liability insurers directly. Except in case, again, of marine and transport insurance. In all other types of liability insurance policies, this direct action right will exist, and for all types of damages. So not like in the Netherlands where it's only for bodily injury after car accidents. In Belgium, it's also for pure financial loss in case of a D&O liability or a professional indemnity case. The only condition there is that either the insurance policy or the underlying liability dispute between the victim and the insured must be governed by Belgian law in order for the victim to be in a possibility to file a direct claims right against a liability insurer. Turning now to the hot item of today, coverage or not for SARS-CoV-2 or COVID-19 in Belgian insurance policies. We don't have a regulator that is interfering in that subject in the way that the FCA in England is interfering. The FCA, who now is actually litigating against a number of British insurers before UK courts to obtain precedent judgments, declaratory judgments, especially in relation to business interruption losses. Our regulator doesn't have such power, and I think would be reluctant to take that sort of initiative as well. There is no published case law yet on COVID-19 in Belgium. There is now one case we are aware of where an insured under an event cancellation insurance policy has sued the insurance market, which we will represent, but that case will only be introduced in Antwerp in September, and taking into account the judicial delays may only lead to a judgment, if it's not settled before, in 18 months or 2 years. The judgments that have been rendered in France or Germany have no precedent value in Belgium for very obvious reasons. We are a civil law jurisdiction. We don't even know the rule of precedent, and these judgments relate to a different legal system and to insurance contracts which are not necessarily even offered on the Belgian market here. But the basic principle is that coverage for pandemics and epidemics is in principle allowed under Belgian law, but at the same time, excluding pandemics or epidemics is also allowed, okay? So it will be questioned, therefore, when you are dealing with a COVID-19 loss, such as we have been doing in the last few months under all risk property, under event cancellation, environmental risk liability with an endorsement for a BI loss, that the first exercise you will have to do is check your policy wording. And the first thing there is to establish whether there's a difference between an all-risk insurance policy, where in principle everything will be insured and the insurer will have to rely on an exclusion clause in relation to pandemics, and a named perils insurance, where the insured will have to prove that the losses caused by pandemics or epidemics are insured. Having said this, then we have to look deeper into the pandemics or epidemics cover or exclusion clause to see whether it covers all of the pandemics or epidemics, known and or unknown at the time of inception of the policy, or whether it is limited only to a number of very specific viruses and diseases that are actually named in the insurance policy as well. Because in that situation, we need to see whether the listing of those viruses and diseases is done in a limited or restricted manner or by way of example. So it's all sorts of questions that we need to ask in relation to the specific policy wording. Second important question is whether the insured has the burden of proof in order to claim business interruption losses, that he has also suffered a property or physical damage, which actually is the market practice in Belgium. We don't have any real market for selling business interruption coverages without property damage being required and insured under the same policy. The question there is going to be whether the presence of SARS-CoV-2 on materials constitutes a case of property and physical damage. And as a judge in New York recently decided that it would not be the case under New York law, I very much doubt it would be the case under Belgian law. there would be no coverage because there is no evidence of property or physical damage, unless you have coverage extensions for notifiable or communicable diseases, however, which may have different wording and not require the presence of such property damage. And finally, and that's a comment that particularly relates to liability insurance, if your insured is held liable for a certain loss that is caused during Corona times, and then you need to check whether he is in a position to invoke force majeure or act of God under the contractual provisions or under Belgian statutory law. I conclude with a number of general conclusions. What I think that in terms of insurance claims and insurance policies, foreign insurers should know when they enter the Belgian market. First of all, beware of a heavy regulated system with mandatory insurance contract law with which you have to comply. Not only in the situation that you choose Belgian law to be the governing law of the policy, but also if you choose a different law, which sometimes is possible under large risk insurance policies, because our regulator considers all these mandatory provisions to be general good provisions that must be complied with in case of doing business in Belgium. Secondly, if litigating in English is important and crucial for you, choose arbitration, because before the state courts, you will end up in Dutch or in French. Don't count too much on mediation, not because it doesn't exist, but it's not really part of our tradition yet at this moment to use often in the case of, for instance, coverage disputes. Be also aware of the fact that for a series of products, there is not really much sophistication in the market in terms of the courts. To give you one good example, there is not one single judgment known or available in our Belgian published case law that deals with a coverage dispute under a D&O insurance policy. That is basically very often because D&O is, like in many markets, a very sexy product where insurers want to be active. So if there's a dispute, it rather fairly easy gets settled more easily than in other insurance products. But you wouldn't find a judgment, unlike France, for instance, where I know that the highest court, the Cour de Cassation, has rendered at least 3 very important judgments on D&O insurance contracts. And finally, this is a market where you have very powerful insurance brokers. You have the big ones like Aon and Marsh, but you also have very important local insurance brokers, to name a few, Van Breda, Alia, you have Van Dessel, and these brokers have quite some buying power, which they also use in terms of claims handling. And that's a factor to weave in, which is at least as important as the strictly legal factors. This concludes our presentation, and I turn off back again to the Legal 500 people and ask Alexander to join me to hear whether there are any questions from the audience that we are happy to take now.
There are indeed. Thanks very much, Hugo. So the first question we have, I'll read these out if I may. The first question comes from Jackie Bickerton in the UK, representing Waitmans, and she asks, if a UK insurer underwrites a risk outside of the UK, post-Brexit, so after Brexit, a UK insurer underwrites a risk outside of the UK for a client which has its head office outside the UK, but where some of the risk falls into Belgium, can they write the risk on the same stamp, or do they need to underwrite the risk separately?
Please go ahead.
I can take that question. So the territorial scope of Belgian insurance law, or at least prudential regulations, is based on the location where the risk is situated. Right. So in that particular case, it will depend on the product to determine where exactly the risk is situated. So the moment when the risk is situated in Belgium, you will need an insurance carrier with authorization to carry out those activities in Belgium. So in practice, you can use a cooperation agreement or with another carrier from your group or split it up.
Or you could, but that needs to be seen as well. You could use a Belgian insurance company to be your fronting insurance company for the Belgian part of the risk, which you often see now already in international programs. When there's a risk in Brazil that is part of a property program where European insurers cannot write business, they will use a local insurer and then reinsure it into the London market. I would think that in terms of the possibility to reinsure continental European risks into the London market in the future, that the ability to do so would still be greater than it is for direct insurance, because it's a completely different market where there is less consumer protection that is needed.
Okay, excellent. Well, hopefully that answers your question, Jackie. If you have any follow-up, please let us know in the comments box. And indeed, if anyone else has any other questions, do please ask them now. Okay, another question comes from Torsten Hildebrand, who is representing the Wertgarantie Group in Germany. So I'll see, Torsten, hopefully I can succinctly reformulate your question. So his question is essentially on empty shell versus service companies within an insurance group. So in cases where the company's directors are all employees of the company, including key functions, and organized in outsourced service companies, is that forbidden under the rules in Belgium?
Well, there are numerous aspects that apply here. So first of all, directors that are employees, that's no longer possible in Belgium. We had a major reform of Belgian company law in the last years. So every director must be a self-employed person. For senior managers, you can still use employees or even outsourced service providers. So that's as a basic principle. Now, who needs to be actually on the payroll of the insurance undertaking depends also on the how large your insurance undertaking is. Can you rely on the principle of proportionality or not? Let's take, for example, the independent control functions. National Bank puts it as a best practice that independent control functions are on the payroll of the local company in Belgium. However, best practices, if the principle of proportionality applies, a comply or explain principle applies. So you do not need to comply with best practice, but if you don't, you need to explain why to the National Bank. So there is a bit of leeway for smaller insurance companies. However, as a general principle, all those rules on empty shells, it's a very complex matter, and it's not because there is one breach. I wouldn't call it a breach, but let's say a breach of one principle. That doesn't mean that you are immediately an empty shell. So I would recommend to look at the specific situation of that company, taking into account all elements to consider after that consideration whether there is a breach of the substance requirements or not.
Okay, excellent, great. Thank you very much. I'm particularly interested to hear questions from UK insurers who are looking at Belgium, so please do submit those now. Another question, so Alexander, from what you have said in your presentation, it sounds very much like applications are still coming in, that UK insurers are still applying to have an office in Belgium. If you ever speak to a UK General Counsel in any sector about Brexit planning, they'll often say, we did all our planning months ago, and that this would seem to suggest that that's not the case. So what's your perception? I mean, are you handling a lot of requests for advice? Are these becoming increasingly frantic and panicked as December 31st draws nearer?
Well, no, the insurance undertakings, they have finalized their Brexit contingency planning. Well, we're 2020, it would be a very big problem if they would not have. But insurance intermediaries, we still get quite some applications of brokers, MGAs, cover holders, agents, you name it, who has waited until a transitory regime in the context of the withdrawal agreement or the Belgian Brexit law, which is still not there, and who are now still taking action. We also see some in insurance undertakings who have finalized their contingency planning, but then suddenly realize that they have a small part of their portfolio still present in the EEA, and then question, okay, is it really necessary to transfer that portfolio via the regulated procedure on portfolio transfers, or are there other solutions, for example, in the context of the principle of proportionality?
We also see that obviously through the experiences also at the level of the regulator, there are some lessons learned out of the first experiences of brokers who decided to set up and the questions they had, that also the regulator now is getting trained into it and is able to act with these requests more efficiently.
Okay, great. Do you have any sense of how popular Belgium has been as a destination for intermediaries relative to other European jurisdictions? I mean, is there any data on that, or is that something you've heard as anecdotal evidence from the regulators?
Well, one of the main benefits of Belgium, of the regulatory framework, as I said before, is the language of the regulator and the flexibility they show towards intermediaries coming to Belgium on the one side, and then secondly, the fact that Lloyd's came to Brussels. We can't deny that has a major influence on the decision of a lot of brokers active on that market in London.
Yes, excellent. Okay, great. Well, look, thank you both very much. Wonderful presentation. I'm sure you'll both be happy to take other questions after this webinar by email, and indeed through the video. So if anyone watching the video or watching the presentation now has any further questions, please do email either Alexander or Hugo or myself, and I'll forward it. But thank you all for tuning in. Thanks to Lydian for a wonderful webinar. Hugo, any final words for us?
Well, thank you very much for attending on our behalf. I would have loved to share all these messages with all of you in person, either in Belgium, elsewhere, and in particular in London. And I really hope that we will be back in 2021, because that would also mean that all of you in England would be back in your offices. Have a nice day.
Thank you very much. Goodbye.
Bye-bye.
Bye.